Welcome to today's NAIOP Solutions Series program entitled Retail Leasing in Office Buildings. I'm Sheila Vertino, and I'll be your host. Today's Solution Series programs are available at no cost to NAIOP members. These are mini webinars, and they typically run less than 30 minutes. The goal, as many of you know, is to provide some quick tips and insights, those kind of practical strategies, tactics, things to help you succeed in today's rather tough business environment. Please let us know the topics that you'd like us to cover in the future, and if you know anyone who would be a good presenter, let us know that too. You can send us an email to solutions, SOLUTIONS, at NAIOP.org, and let us know. Okay, we're ready for the next slide, and I want to talk a little bit about some other options that we have. As I said, the Solution Series programs are kind of those educational tidbits, a little snack, if you will, of information. But there's some topics where we want to go into more in-depth discussion. And for that, we have 90-minute webinars. Now, as you can see on the screen, the next one is on healthcare reform and how that's affecting medical development. Big topic. Then this will take place on Thursday, March 3rd. It'll explore the likely impact of healthcare reform on medical real estate and identify some demographic trends driving demand for medical office space, describe the type of facilities that will prompt this future demand. The cost of these webinars, they're 90-minute webinars, and they're fully interactive. The cost is $65 for NAIOP members and $95 for non-members. If you'd like to register for this program, you can see on your screen, you go to NAIOP.org/webinars. And now let's get on with our Solution Series program. I'm pleased to say that with us today is Matthew Weinstein. He is a member of the Business Law Department of Cozen O'Connor. Matthew has extensive experience representing real estate developers and shopping center owners, landlords in all aspects of the acquisition, development, financing, leasing, and disposition of commercial developments. He also represents many local, regional, and national tenants and landlords in negotiating office and retail leasing space. And that can be in shopping centers, office complexes, industrial sites, technology parks, and incubation centers. So you can see he's got a tremendous experience, expertise in the topic that we're talking about today, which has to do with the retail leases in buildings that typically have office and are going to be negotiated typically by office landlords and owners. So welcome, Matthew, and thanks for being with us today.
Thank you, Sheila. Again, I'm going to be talking today about some of the things that office landlords and office tenants honestly should be thinking about in connection with retail space and office buildings. The first two slides I'm just going to go through very quickly. This is just sort of an overview of what I'm going to be speaking about today. We're going to talk about just some of the overall differences. We'll talk about CAM, signage, subordination, non-disturbance agreements, nature of the parties. Also talk about the security deposits, issues regarding terms and renewal options, delve in a little bit on assignment and subletting, condemnation, some unique issues on events of default, and then also talk just very briefly about some rights of first refusal and rights of purchase. So on to the crux of the quick presentation here. So one of the overall issues is really just to see the difference between office versus retail leases. Many landlords, and honestly many tenants as well, believe that if they're competent in one area of leasing, they're competent in all areas of leasing. But leasing is very different if you're in a retail context, if you're in an office context, if you're in an industrial or warehouse context. There are issues that are unique to each of those. And this presentation is really going to go into some of those unique issues that you should think about when you are negotiating these types of leases, specifically in this context, retail leases within an office building. So the first thing, and this is really sort of the genesis of this presentation and where my interest was piqued, many of my clients, I'm an attorney, are office landlords. And because they've worked in the office leasing business, they believe they know leasing in all aspects. And there are some unique aspects that are very specific to retail leasing that are many times lost in the office context. So the first issue I just want to explore is really to think about from a business perspective is that retail leasing for many office landlords is not their core competency. And that comes out in a bunch of different areas. One of them is the area of what contacts they have in the business world. Many of the contacts with office landlords are with office tenants, whether they're in the life sciences world, whether they're in the legal world, financial world. The tenants that they have contacts with are office-type tenants, and many times they don't have those types of contacts in the retail leasing world. And where this becomes an issue is where you have an office landlord that may be an owner of an office building, acquire an office building, and all of a sudden the retail tenants leave. Leases are up. It's not the right place for them, and they have to fill those tenants' vacancies with new tenants. There's some tremendous leasing issues that many landlords may have when they don't have the contacts in the retail sector. Certainly there are organizations that we can be involved with. NAIOP certainly is a wonderful asset both on the office side and also as well as a resource on the tenant side. Another obviously great resource would be the International Council of Shopping Centers and BOMA. But it's very important to retain those contacts and to build those contacts in retail if you are an office landlord to avoid any reletting issues. Another item that you want to think about as an office landlord is actually what purpose do these leases have within the context of your building? Is the lease going to be used as an amenity for the tenants in the building? Is it going to be used as a profit center? How the leases are structured, how the rent is going to be structured. In fact, what the rent actually will be is going to depend on whether this is a cafeteria-type store on the first floor of an office building, a bodega selling, chewing gum, cigarettes, soda, or is this going to be, a McDonald's, a Burger King, a Starbucks that's really going to be a profit center for the building? How the leases are negotiated, how they're structured is very much going to be dependent on how you answer that question, which of course is very different than what you have in an office setting where the folks in the office setting are there to have offices. And it's much more of a one-size-fits-all. Tenant mix, another thing that's also very different on the retail side. You want to make sure, certainly as an office landlord, and this is something that tenants in a retail situation are very much looking at, is what other tenants are in the center? What type of traffic is going to be created? Is the traffic just going to be from the office tenant? Is this a city context where you're going to have people coming off the street? Many retail tenants don't want to be close to other tenants of their specific type of retail use. For example, a Starbucks may not want to be, and in fact may insist that they are not near another coffee place. They want to be that exclusive user. If you look at it in an office context, and you have, let's say, a life science type of use, many times, many life science places like to be together. Banks may also like to be together. Law offices may also like the collegiality. Very different in a retail context where the diversity and creating traffic is what's really bringing those folks together. Visibility, this might be the #1 issue for retail tenants. Retail tenants want to know that somebody could see their sign. This is a huge issue in city projects where you might have scaffolding issues. A little bit less so in suburban offices where really the only visibility is whether people can see it from the road. But in the city context, it's very important. It's going to be something that in these leases the tenants are going to be focusing on with a laser-like focus. And it really has to be dealt with how that is going to work, how the visibility is going to work, and deal with scaffolding issues, deal with visibility issues up front, because they will be an issue down the road. Another approach, and this is really an overall approach that certainly can be its own topic in and of itself, is condominiumization. What this is that there are, as I'll talk about in CAM in a moment, the way CAM works in office settings and retail settings is very different. Office users, by and large, for example, don't use much water. Certainly a coffee store, a restaurant, a haircutting place is going to use a tremendous amount of water. And how that, from a common area perspective, if it's not separately metered, how those are split up is unique to a retail setting as opposed to a office setting. One of the solutions that many office landowners will create in order to get past this issue, which sometimes could frustrate lease negotiations, is, and certainly post-lease and post-operation issues, is by splitting up the building into an office set portion of the condo and a retail portion, and that allows you to separate out the costs for example, water and other CAM expenses between the office portion and the retail portion. And then the last thing, which we spoke about a little bit earlier, just on sort of the general overview, is suburban office parks versus downtown office buildings. You know, if you're in an office setting, really not much different. If you're in a suburban office park in the city, there might be some parking issues. Major issues with respect to visibility and accessibility in suburban office parks versus downtown office buildings. How people come through a lobby in a downtown office building, where they may be able to park, dedicated parking spaces, visibility from the street. These are issues that are going to be very much looked at by a retail tenant in a downtown area as opposed to a suburban area, and very different from what an office tenant is going to be looking at. So getting into CAM and taxes, the major difference that I really want to highlight here is the difference between the triple net leases that are what you're going to see in a retail setting as opposed to the gross leases or expense stops that you see in the office leasing. In retail leasing, tenants expect that they will have triple net leases, meaning that they will pay rent, and then above that rental, they will be paying common area maintenance charges, taxes, and insurance. In an office setting, tenants many times expect, and landlords can certainly set it up this way, especially if it is a shorter office lease, to have gross leases, where everything is included except possibly electric. This just doesn't work in the, and is not typical in the retail sector, and it is one thing that you really need to kind of brace yourself for when you do negotiate a lease in the retail sector. Gross leases, expense stops, it's just not concepts that are typically used in the retail sector, and the office landlord is going to have to understand that up front. The other issues, especially with national tenants, is they look, again, with a laser-like focus on the specifics of what is in and excluded from CAM. Management fees, capital expenses, these are items that the tenant in a retail setting simply just doesn't pay for. Office tenants, you can get away with this much more often, but the retail tenants, especially the nationals, have policies in place where they simply will not agree to this. On signage, again, we talked again about one of the main issues that the tenants have. Signage and retail tenanting is probably the most important part of their lease. An office tenant, you know, even if you are a major tenant, yes, you might want your sign on the building, and true in office leases, that could be a difference between locating in a building or not locating in a building. But with retail tenants, if they don't have signage on the building, they're simply just not going to locate it there. Starbucks wants people to know that there's a Starbucks in the building. McDonald's wants people to know there's a McDonald's in the building. Not only do they want them to know that they're in the building, but they want to make sure that their logo, that everybody sees all over the region, country, and in many cases the world, is the same exact logo that they're going to be able to put on your building. And they're going to want to know that any sign criteria that you might have will allow them to be on the building. They're going to want to know that any legal requirements, governmental requirements, will allow them to put it on the building, and they're going to want to make those signs as big as possible. This is just a major issue for retail tenants, and it's something, even in the letter of intent stage, really should be negotiated as to what type of signage they can put in the building. And with suburban office parks, even more so than the office complexes that are in the city, whether a tenant will even have a space on the pylon sign is also very important. This visibility, this signage, is just an extremely important factor for retail tenants. The parties, you know, some of these issues are a little bit similar in the office context. With respect to a landlord, you know, make sure you know who the landlord is, especially if you do go the condominiumization route. Make sure that the landlord of the condo that's the retail condo is in fact the landlord in the retail condo. With the tenants, really the biggest difference that you have in retail context is that tenants in the retail context are usually more than just one premises. And many times, especially in office buildings, they are national and international, or at least super regional tenants. And those tenants may not be the corporate tenants. They could potentially be franchisees, sometimes one or two stores. sometimes 100 or 200 store franchisees. But it's very important, as I get to this guarantor issue, to understand who that tenant is. When you're dealing with office tenants, typically the person that's the office tenant is the operating company, not unusual at all. Occasionally you'll have a subsidiary that will be the tenant, but for the most part it's your parent company, the mothership. Not true in the retail setting. Most retailers, especially if they're a retailer that is in many states, will set up single-purpose entities for regions. Franchisees, again, might truly be a shell company where the only asset is the 1, 2, or 3 stores that they have. Very important to look at the financials of those companies, understand what their financial net worth is, understand who's backing them up, whether it's a corporate entity that will back them up, or whether it's an individual that will back them up. In a franchisee, it's typically an individual that will have to give a guarantee. In the context of a larger multinational, many times cell phone stores do this all the time. You'll have a local single-purpose entity, and you can get the corporate folks to guarantee. The length of the guarantee in the retail setting is always up for debate, but suffice to say you want to have something that's a meaningful length of time, whether it's just for the initial term or at least enough time so that the tenant allowance, at the extent you give it to that tenant, it has a chance to be amortized. But it's very important to look at who the parties are. Subordination, non-disturbance, and attornment agreement. Really the big thing here is many times you can get away with, unless it's an extremely large tenant in an office building, not requiring SNDAs. The tenant will agree to self-subordinate, and that way you don't get into any issues of whether a tenant executes or negotiates an SNDA in the event that you want to sell the building, want to refinance the building. However, in the retail setting, tenants invariably will require this. For whatever reason, retail tenants just believe that they're entitled to an SNDA regardless of whether there is a self-subordination in the lease. And it's something to really consider, maybe as a landlord, even back off from or use it as a negotiating technique as to something that you'll be able to give in order to get something else in return. Security deposits, really the advice here on the retail tenants is to lower your expectations. With an office tenant, absolutely, you're going to be able to speak with them and you're going to be able to get a meaningful security deposit, certainly if there's tenant allowance. With franchisees, most likely you'll be able to get a security deposit. Many times you're not going to get more than 1 or 2 months. Certainly, it's very, very rare, even on franchisees in a retail context, to get 4 to 6 months of security deposit, which very well may be the norm in many of your office tenants. With the national tenants, almost impossible. They just don't want to give and don't want to part with any portion of their money for any period of time. And it's very important to lower that expectation going into a lease, and certainly if you want a security deposit, to try to raise that in the letter of intent stage. But make sure that you understand as a landlord that this may not be an item that you're going to win on with respect to the lease negotiation. Terms and renewal options. Retail leases, unlike office leases, are very tied to the location that they're at. If you think even about driving around the neighborhood, you know where your Payless shoe source is, you know where your gas stations are, you know where your restaurants are. Where those restaurants are, the side of the street it is on, where the traffic is, the familiarity that people have of going to that same location year after year after year is very important. And where that comes out, not just on relocation rights, which are very similar in office versus retail setting, but in the terms of the leases. Tenants need the flexibility to stay in that place as long as possible. They are going to want to have, in many cases, a short term with tons of renewal options, which might be very different than what you have in an office setting where they might just request one long lease. There's a sense of how the company is going to grow a little bit more in an office context. If you're located, I'm in Philadelphia, if you're located on 19th Street in Philadelphia, and that's where your office is, but your business that you do gets a little bit more national, well, you could still operate out of Philadelphia. With a hamburger store, if tastes change, people might not be eating hamburgers on one part of the city because it becomes an older population, whereas the other part of the city might be a younger population. They want to move, even though that's a quarter mile, a half mile, a mile. there's flexibility that retail tenants want. And you need to keep that in mind when you're looking at these leases as to how you're going to negotiate the rent, how you negotiate the term, even how you negotiate the tenant allowance, to understand exactly what that term is and to understand that the tenants do want to stay a long time, but they want to have the option to leave if retail tastes change in the location that they're in. Assignment and subletting. Again, this is something we sort of touched on earlier with the franchisees that many times you'll have in a context of a retail site. Those franchisees, for whatever reason, may breach their franchise agreement, might not be profitable there. You need to have some flexibility so that the franchisor, the parent company, is able to take over that franchise contract. It's something that's typically negotiated up front, really not something to worry about from the landlord's perspective, mostly because you get actually a better tenant when you have the franchisor that's going to come in and take over the lease. Related transfers, this is not quite as important in the retail context, but there are certainly takeovers that occur in the retail context, different than what you have in the office context, but that flexibility is also worth adding to the agreement. Condemnation and destruction. This is also one of the puzzling issues on the retail side that retailers that go into office buildings don't really understand, and honestly, office landlords with retail tenants, I think, tend to ignore. Many times you'll have 300,000 square foot building, and you have a 1,000 or 2,000 square foot retail tenant on the first floor. Well, that tenant is going to want you to rebuild the entire building, which is just absolutely ridiculous in the context of a condemnation, and certainly in the context of a destruction. It's really the tail wagging the dog. Many times this is an issue that is sort of followed in the breach. The loan documents are going to say we don't have to rebuild in the event that there's a casualty over X amount of space. The tenant's going to say, I don't care, I've got all this tenant improvement allowance that's in here. And this is just an item that is going to have to specifically be looked at. And when there is a landlord office lease form that has a very specific way of doing the condemnation and casualty proceeds, it's worth having an outside attorney or consultant take a look at that casualty provision to make sure it works in a retail context. Since what tenants expect, and honestly what tenants are entitled to, and how the tenant improvement allowance might be allocated in the event of a casualty, it is different in a retail context than what you have in another context. Also, just a little issue again on visibility and access, two big issues that tenants have. In the event of a casualty or in the event of a condemnation that affects access, it's very important that how the common areas are affected by a casualty, meaning a lobby, or in a condemnation context with access, be dealt with in the lease. You don't want a situation, and retail tenants love putting this in, that a condemnation or casualty of 25% of any portion of the center, which could include just part of the parking area that doesn't even affect the access ways the tenant, can cause a ability for the tenant to terminate. And you just want to be mindful of that. Events of default, again, the issues here are really the same in an office and retail context, but what I do want to highlight is many tenants in the retail context, because they are national tenants, don't understand state issues, and even when they do understand state issues, they choose to ignore it. One of the items that's near and dear to my heart, since I am in Philadelphia, is confession of judgment. In Pennsylvania, you are allowed to, landlords can actually confess judgment for monetary damages as well as ejectment, getting somebody out of the premises. Very recognized in Pennsylvania as a remedy. National tenants see this and they can't handle it. They said they don't see it in any of their leases, which is true. It's not going to be in leases that they see in New Jersey. It's not going to be in leases they see from California, Arizona, anywhere else. But it is something that takes place in Pennsylvania, and you really need to be prepared to be able to educate the tenants as to what remedies are acceptable, and in many cases educate the attorneys that are negotiating on behalf of the tenants in the retail context, so they understand what is a typical remedy, and you can get those remedies that you would otherwise be protected with as a landlord into these retail leases. Because certainly you have them for your office tenants. There's no reason that you shouldn't have it for your retail tenants as well. And then just sort of as the last item here, I wanted to talk just quickly about rights of first offer, rights of first refusal, and purchase options. Certainly this is something that you see in the office context. Absolutely is an issue in the retail context as well. And this goes for both the office and the retail. It's very important for the landlord to understand what space they have agreed to give to office landlords or to tenants in a retail context, excuse me, office tenants and retail tenants. It's always very awkward when an office tenant is granted space in the retail portion, or if it says something as broad as any space that comes available in the entire building. It's very important for landlords to specifically say, okay, there is a retail component to this building, there is an office component to this building, and we need to make sure that we understand that we are giving a right as to the retail component for the retail folks, to the office component for the office tenants, and that way there's no confusion or awkwardness as to who is getting space in what portion of the building. And this goes back, again, even to something I talked about at the beginning, which dealt with the tenant mix. You know, tenants in the retail context want to see foot traffic. A software company on the first floor of a building doesn't create foot traffic. The retail folks want to see that foot traffic. They want to see it on the retail portion. Really don't want to get mixed up with the office folks in prime retail space. They want to see that foot traffic. They want to see, if it's a suburban office, the car traffic pulling up to that building. They don't want space taken that looks dead. And it's just something very important when looking at these rights of first offer, looking at these rights of first refusal, granting it, making sure that the right areas and the right tenants have the ability to go into the area of the lease, in the area of the office building that is most appropriate for them. So that includes my 20-some-odd minutes here. Certainly, if you have any questions, please give me a call. And now I'll turn it back over to Sheila.
Thanks, Matt. That was really fascinating. There's certainly a lot of differences in places where people could get caught up in little nuances with the differences between retail and office leasing. And so I really appreciate your sharing all of those insights with us today. For our listeners, the next Solution Series program will be available on February 22nd. And we'll send you an email. It will come as the NAIOP source, which is our new corporate newsletter, and the program link will be in there. And you can just click on it and listen to it right away. So thanks again, Matt, for today's presentation, and thank you all for listening. Goodbye for now.